Welcome to Brief Encounters. This is the fourth episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner at Armstrong, Teasdale, and I'm also the leader of the firm's Securities Regulation and Litigation practice. With me is my co-host, William Nelson. William, can you go ahead and introduce yourself?
Yeah, hi, William Nelson. I'm an Associate General Counsel for the Investment Advisor Association. And, Valerie, I can't believe it. We're already up to four, so very exciting.
It is. And we're going to keep going because we've had a lot of great feedback. And we do have a special guest today. We have Karl Egbert, who is a partner at Baker McKenzie and the co-chair of the Global Private Funds Group. Karl, welcome to our series. How are you?
Good to be here, Valerie. And William, always nice to hear you as well.
Excellent. So, Karl, today we're talking about the private funds rule and what has been a tumultuous summer when it comes to not just the private funds rule, but SEC rulemaking as a whole. As you know, our point of view in the podcast is to take a look at current securities regulatory and enforcement issues, but through the lens of Dodd-Frank. We're working up to the 15th anniversary of Dodd-Frank next year. But so today we're talking about the private funds rule, but let's start with going back to Dodd-Frank, which was really a watershed moment for private fund advisors generally. And we were hoping you could tell us a little bit about that.
Well, right. So the longstanding position before Dodd-Frank was that the SEC generally didn't substantively regulate private fund managers. Not that it hadn't tried. It had tried before to eliminate the old investment advisor exemption, but it lost in 2006 in SEC v. Goldstein. And so it had tried to regulate private fund advisors before, but then the financial crisis allowed the SEC and other market participants to sort of relitigate the Goldstein decision. And Dodd-Frank gave the SEC power to regulate private funds in at least some context. So, for example, it created a new kind of exemption for private fund advisors that would allow the SEC to get some information. Obviously, Dodd-Frank did a lot of other things that affected private fund advisors, including, swaps reporting, things like that. But, what it didn't do is give the SEC broad authority, at least not clearly, to substantively regulate private funds. It eliminated exemptions. It pushed more advisors into registration. It pushed even more advisors into the private fund advisor exemption. But, that is a little different. Requiring registration is different from substantively regulating investment advisors' relationship with private funds. And that's partly because that's, the United States and our securities regulation has generally respected freedom of contract between sophisticated parties. Sort of longstanding tradition that we've had and our regulatory and legal tradition is that if two parties agree to a mandate and they're sophisticated and they understand what the risks are, what the conflicts are, then they should be free to do that. And Dodd-Frank wasn't really intended to change that. It added a lot of substantive regulation to private fund managers and allowed regulators to have a lot more transparency into what private fund managers were doing. But that was different from substantively regulating that relationship. And so, I think that's what eventually led the SEC to the private fund advisor rule. But that's where we were with Dodd-Frank. And, thank you for reminding me that it's 15 years ago almost. Time flies, I guess, when you're having fun with securities regulation.
Absolutely, Karl. And, you're absolutely right. Dodd-Frank is entering its teenage years. We don't know how it's going to go, but we're gonna find out soon. But I think that's a really good introduction. So we've talked about kind of the genesis of Dodd-Frank, how it impacted the private fund industry, greater disclosure, greater transparency. But fast forward again to where we are now. Talk to us about the private fund advisor rule, and then also kind of the court's holding on why they believe that the SEC didn't have authority to go forward with that rule.
Right. So recall that I was saying before that Dodd-Frank didn't at least initially appear to give the SEC authority to substantively regulate the relationship between sophisticated parties. So we're talking institutional investors, high net worth investors in private funds and the private funds themselves. The private fund advisor rule was an attempt to mandate specific reporting to investors by advisors on behalf of the private funds with respect to the private funds that they manage. It was an attempt to regulate certain conflicts, certain expense allocation practices, things like not allocating broken deal expenses to co-investors. And at least initially, it was an attempt to redefine fiduciary duty. And I know that the staff would disagree strongly with the statement that the private fund advisor rule was trying to redefine an advisor's fiduciary duty. But I think, there are times when the staff, didn't seem entirely clear on what the impact their pronouncements on fiduciary duty might have. And I do think it did represent an attempt to expand and limit an advisor's ability to agree on the services that they were going to provide to investors. The SEC's longstanding position, and a position I understand, is that an advisor cannot waive its fiduciary duty. But I think the more precise way to state that is an advisor cannot waive its Advisors Act fiduciary duties. It has to be able to waive or shape its state law fiduciary duties, including the duty of care, because when you say that we're going to look at X universe of securities and not Y universe of securities, you're limiting the scope of what you're doing. You don't have a duty of care to look at securities they haven't promised to do. And so when the staff was saying things like, you can't waive your fiduciary duties full stop, people in the industry had to hold up their hands and say, hey, wait a minute. Didn't you just say in the fiduciary duty guidance that advisors and clients were able to define the scope of the advisor's duties? Didn't you just say that that was possible only a few years earlier? And so what it looked like to many in the industry is that the private fund advisor rule was getting right in the middle of that relationship between an advisor and their clients and their investors and their sophisticated investors, and sort of overturning the apple cart of our longstanding tradition of allowing those relationships to basically be decided through negotiation. In terms of what the court didn't like, I think the court didn't like two things. And unfortunately for the SEC, the two things that they didn't like were the two bases of statutory authority for the SEC to pass the rule. And those two bases for the SEC statutory authority were Section 211H and 2064. Now, 211H was a section of the Advisors Act that it was drawn from Dodd-Frank. So going back to Dodd-Frank. But the underlying authority in Dodd-Frank in that section refers to making rules governing the relationship of advisors and their retail investors. At least it goes that way through 95% of the section of Dodd-Frank until the very end, where there's a sentence or two that says that the SEC is free to adopt rules regulating the relationship of advisors and investors. No retail investors. And so it's that little hook that the SEC staff relied on to expand how they would, they took that small hook, try to use that to expand the SEC's rulemaking authority with respect to private funds. So it's a section almost entirely devoted to retail investors, but in the final piece of the section, it omits the word retail. Right? This is a classic law school problem, which is to say that I don't think it's a real world problem. The entire section is devoted to retail investors, and you admit the word retail a few times at the end of the section. That really equates to Congress intending to give the SEC authority to regulate private funds in a section that's about retail. And I can just imagine the conversation that happened on the SEC staff, because, yes, it's a question of statutory construction, but, if Congress really intended to hide the SEC's authority to regulate private funds at the end of a section regarding retail investors, shouldn't they have at least talked about that? Congress was regulating private funds during that time period, and this just wasn't part of that regulation. So what would that conversation at the staff have looked like? It would have had to have been something like, well, this looks to me like a section about retail investors, but, maybe Congress intended this final clause to be about hedge funds. And then the chair looks at the staff and says, so you're telling me there's a chance? And I think that's what they did. They ran with a 1 in 100 or 1 in 1,000 argument that this section could be stretched to private funds. They invested considerable resources to develop rules around this authority and then had to litigate. And I think that's a bad strategy. I think it was a bad decision. We all want, I think, good regulation. And I think we all want the SEC to have the right resources to do its job. But that just doesn't seem to be a good way to use resources.
So with that as the backdrop, Karl, and this was great because you gave us sort of your thinking on the relevant provisions that were at issue in the Fifth Circuit litigation. Were you surprised at the breadth of the opinion? Or do you think to some extent we could all see it coming?
Well, I was surprised at the breadth of the opinion. I think we're still getting used to the idea that the Fifth Circuit is, so incredibly receptive to these decisions that even though I know that they were looking to limit Chevron deference and end Chevron deference and, limit the use of administrative law judges, and, realize we may be talking about some of those things later, but it's still surprising to me just how receptive they are and just how skeptical they are of agency authority. And that comes right to the case. So, I don't think the use of 211H was wise, but is there a court out there that would have accepted it? Probably there are some, but I wasn't surprised that they eviscerated the SEC's use and the staff's use of 211H for private funds. I was, however, surprised by their somewhat cursory and less reasoned take on 206.4, which was the other statutory basis for the SEC's authority to pass the private fund advisor rule. And 206.4 is a more general anti-fraud authority. And the court there seemed to be saying that unless the rulemaking could show kind of a direct relationship between fraud and the rules that it was passing, that in those circumstances, the commission didn't have the authority to pass the rule. That, to me, superficially looks a lot more like the Goldstein or the Chamber of Commerce decisions that went against the SEC from a generation ago, where the SEC just needed to do a little bit more work to put content into its rulemaking. The thing that's changed, obviously, is the willingness of courts to defer to the SEC's judgment about those things. So even though that felt superficially to me like maybe Goldstein, where the staff could lick its wounds and come back with something else or other rulemaking priorities. But when you couple that with the limits on, the ending of Chevron deference and the limits on ALJs and administrative courts generally, it starts to feel like a very different world where this is going to be tough for the SEC to come back and figure out how to use 206.4.
Yeah, and thanks, Karl. And I think that's a great discussion. I know we've talked about kind of these recent Supreme Court decisions, really focusing on agency authority, the use of in-house agency resources for enforcement. What do you make of the SEC's lack of an appeal in this case? Because again, it did incorporate, much broader than this 211H authority. We just passed the 45-day period where they could, automatically appeal to an en banc panel of the Fifth Circuit, but they still have the option of, obviously appealing to the Supreme Court through writ of cert, at least for the next, 40-ish days. But what do you make of that?
Well, what I think is 211H authority is dead with respect to private funds, but 206.4 authority is only mostly dead, and that means it's partly alive. And that means that the SEC really has to preserve its range of motion with respect to 206.4. I don't expect an appeal. I don't expect a cert, partly because I think they'd lose at the Supreme Court. And, again, I have never managed to achieve, despite reading all of these SEC rulemakings over the last 3 years, I haven't managed to achieve a mind meld with Chair Gensler. So I can't always accurately predict what they're going to do. And I know it's not entirely in his hands either, but it just wouldn't make sense to me to seek cert. If you seek cert, I think you run the risk of a much more precise opinion, absolutely eviscerating 206.4 authority. And that just doesn't make sense. And again, the agency has to have some ability to regulate. You may not like a lot of regulations that have come out of the commission recently, but they have to have an ability to go after bad actors and things like that. And I just don't think it makes any sense to risk their ability to engage in rulemaking any further.
Yeah, to that point, Karl, we've talked about, the appeal period has ended in the Fifth Circuit, unlikely to see an appeal to the Supreme Court for the reasons you just discussed. One question I've heard a lot is basically, is it okay to put pencils down on implementation?
Look, I think so. I can't imagine a scenario where this is coming back. Even if the Supreme Court decided to take this up, I cannot possibly imagine that they would allow the rule to be effective and enforced during the period where the case is being heard, especially considering that, the prime reason behind the challenge is that the rule was too costly and difficult to implement, and that the SEC hadn't really worked through all of that, and it didn't have authority in the first place. So making people implement a rule that the Fifth Circuit has found the SEC didn't have authority to pass, that doesn't seem likely. Now, that said, I do realize there are some managers that put a lot of time into implementing these rules. They may have some pressure from investors to continue to implement the rules, or they just may have a compliance infrastructure that makes it difficult to stop something when it's in motion. And, if you have a situation like that, I can understand moving ahead in some respects, but I don't think that's the answer for most of the managers. And it's not been the answer for the managers that I work with.
So looking ahead, do you expect that components of the private fund advisor rule may be reproposed? Or do you think at this point private fund advisors have an uncertain but sort of longer term status quo in terms of substantive regulation by the SEC?
Well, I think the SEC still has tools in its toolkit. The expanded Form PF notification requirements are one of those tools. Record keeping actions are one of those tools, and the compliance rules. So there are a lot of tools to get some of the concepts from the private fund advisor rule into other parts of the Advisors Act regulations. But do I think the SEC is likely to do that? It would have to be dramatically scaled down. So do I think that they want to spend the resources on that? I hope not. Again, I think the agency really needs to think about what it wants to focus on. The chair may not have much time left. And, I think it's a good time to focus on bad actors and focus on protecting, mom and pop investors, which is what the stated rationale behind the private fund advisor rule was all the time. So rather than try to push pieces of the private fund advisor rulemaking into other sections of the Advisors Act where they won't work particularly well and may still be subject to challenge, I think it makes sense to kind of take a few steps back and accept the world as it is and go back to kind of a core mission of protecting mom and pop investors.
Yeah, and that makes a lot of sense. And I think that, we've talked a lot today about the Fifth Circuit, their specific holding, kind of the genesis of the private fund advisor rules, the most recent iteration of that from the SEC. But, it's interesting to look kind of more holistically, right? So, and this is a discussion I want to have with both you, Valerie, and Karl, is that what impact do we think this is going to have on other proposed rules? So right now, cybersecurity rule, the outsourcing rule, predictive analytics, all, at least in part, rely on 211H, but definitely the 2064. And, Karl is a Princess Bride fan. I love the Mostly Dead reference, which is 2064. But, what do we think is going to happen to those rules based on this court holding?
If you had to pick a boulder to roll up a mountain, the predictive analytics release is not the boulder I would pick. That release just had other problems other than the statutory authority. But I also realized that there is pressure on the commission to do something about and to do something about technology. But I hope they've scratched that itch by issuing the proposal, because it just needs so much work besides that. I don't know what they're going to do about outsourcing. I think if you limit outsourcing to the outsourcing with respect to retail investors, you've got kind of a strange rule. And so, that's interesting. Safekeeping, that's another one where I'm not entirely sure that the problem with the rule is the statutory authority, so much as some of the practical issues caused by, the approach to the rule and, banks just telling us, hey, this doesn't work for us. So, I think the SEC has to figure out a way forward on safekeeping. I assume they're going to repropose in response to some of the feedback they've received from industry. And then maybe we'll be able to better evaluate whether they have authority to do that. But I mean, they've got to be able to regulate custody. There's got to be some way for them to do that.
So, Karl, I think you're exactly right. The custody / safekeeping / safeguards proposal suffers from just practical challenges in terms of the banking industry and so forth. And I do agree with you that the predictive data analytics proposal is a very, very tough one for the SEC to finish and pass and finalize as a final rule. Outsourcing to me is the one, I keep hearing it's all cylinders ahead on all these rules, but outsourcing to me is the one that suffers from both lack of authority and practical challenges as well. I do think the predictive data analytics proposal needs to be extensively rewritten and has a lot of other issues. But I think if I had to pick one that should absolutely not move forward, it's the predictive data analytics. I think outsourcing is a close second in terms of another one that should not move forward, both because it suffers from authority issues and also just practical challenges.
The thing about outsourcing that drives me a little nuts is, look, this is already subject to fiduciary duty. And industry says this, I'm not saying anything new, but obviously other jurisdictions substantively regulate outsourcing. But we've always dealt with outsourcing concerns. And the SEC has brought enforcement actions on outsourcing failures under the compliance rule and under other rules. So, there are ways to deal with that make me wonder whether a rule is needed at all to accomplish the policy goal there. So I'm not against regulation. I do like regulation.
Well, and I think you're right, because a lot of the issues that are addressed in the outsourcing proposal really are questions that investment advisors have been asked as part of SEC exams for a long time. I advise clients in many SEC exams over the course of a year, and those questions have come up for a long time and they will continue to come up. I don't think the outsourcing proposal needs to exist for the exam staff at the SEC to ask those questions and for investment advisors to be thoughtful about their outsourcing relationships. Because at the end of the day, as you pointed out, that's subject to their fiduciary duty.
Yeah, Valerie, I completely agree with that. And even, as a former CCO, yeah, those questions always arose in the context of third-party service providers and, the level of oversight required.
I have to say one thing about the outsourcing proposal that also I found incredibly challenging was the record-keeping requirements for the outsourcing proposal when some of the outsourced services relate to record keeping, because the record keeping requirements have gotten so complex. And so it was creating this somewhat absurd result where I think some advisors were going to need to outsource their outsourcing record keeping compliance to comply with the outsourcing rule. And it just becomes a snake that eats its own tail. It's too much. Record keeping is essential. But if we're, having record keeping about our record keeping relating to outsourcing, it just becomes reductive.
Well, and at this point, we're well past the point of smart regulation and well into burdensome regulation. William, I did want to ask you, because as part of your role, you follow many rulemakings very closely, and you and I have had many discussions about the impact of the end of Chevron deference and the impact of the relentless Loper decisions. Looking ahead, where do you see pain points in SEC rulemaking?
Yeah, I think at this point, there's multiple, really. I think that authority piece, especially as we've talked about today with private fund advisors, is 211H truly dead? Can you still use 2064? But yeah, for a lot of these other rulemakings, though, it's going to really depend on, I think, how much pressure is put on the SEC. We've already seen letters being written to the SEC basically saying, hey, we have this circuit decision. Here's what we think you're still able to do under that decision based on their holding that limited your authority. And it's also an election year, right? And just even based on what's happened in the last week, I mean, it's just such a volatile time, for the administration and at these executive agencies thinking, what's going to happen over the next couple of months, and what things, like Karl talked about, what things can I get done in a reasonable fashion that I really do think, won't be subject to an immediate legal challenge. So, again, at this point, I think there's just so much up in the air that I don't envy the SEC's Office of General Counsel right now, because I know that a lot of this is likely, being discussed with them on kind of what can we do over the next few months, again, that won't be immediately challenged in court.
I think those are all great points. And, we're recording this at the end of July because this is our August episode in the series. So, at this point, I think we can only say to be continued. But Karl, do you have any last words for us?
Yes, I have to say that although I never liked the approach of the private fund advisor rule mandating rules for, kind of governing the relationship between advisors and investors, that doesn't mean that efforts to improve reporting and improve transparency should be dead. I know ILPA has come out with kind of a template for standardizing reporting by private fund advisors. And, the truth is the industry needs LPs, and managers have to remember that. And the LPs do have some concerns. And so I think we do have to work with LPs to come up with some of the enhancements that they're asking for. I also think it's a good time to take a look at disclosure and take a look at fund documents. And, if the core of the relationship between investors and private fund managers is disclosure, then I think we do have to take ownership of the disclosure and not try to hide the ball with disclosure, because I know that's something that ILPA and LPs have mentioned as well. We all need each other. And so this is a big loss for the SEC, and I think it was deserved. But investor protection remains a noble goal, and working together in the industry remains a noble goal. So I hope we can all stay committed to that.
I think that's a great note to end on. Karl, thank you so much for being a guest on today's episode. We absolutely appreciate you taking the time. William, thank you for all of your comments today. And I think it's time to say until next time.
Thanks, Valerie.
Thanks, guys. Good speaking with you.